I just want to give a very brief introduction here to our panelists and then turn it over to them. But on behalf of the D.C. region of the ABA's White Collar Crime Committee that Alex Walsh and I co-chair, we're delighted to have this great panel today. Thank you so much for taking your time out to give us this presentation, and thank you for those of you who came here in person and on the phone. Without further ado, I'll turn it over to my partner, Brittany Preliger.
Thanks, Brian. Thanks to the D.C. region of the D.C. Bar White Collar Committee for having us. Thanks to all of you for coming, and for those on the phone for listening in. And thanks as well to Arnold & Porter for hosting us this afternoon and for the delicious lunch. We should note at the outset that this session is being recorded, which means that nothing that's said here is off the record. We're here to discuss a new set of disclosure requirements that are imposed as part of the Dodd-Frank Act of 2010, Sections 1502 and 1504, and the related SEC rulemaking under these provisions, which were issued in August of this year. Both provisions aim to deliver social benefits that seem to most, I think, outside the SEC's normal investor protection remit. Section 1504 aims to increase transparency in resource-rich countries by requiring extractive issuers to disclose payments that they make to governments in those countries for the commercial development of oil, natural gas, and minerals. Section 1502 was a bit of an 11th hour addition to the Dodd-Frank Act. It aims to choke off the trade in conflict minerals, meaning tin, tungsten, tantalum, and gold, known as 3TG, as a source of funding for armed groups that are causing conflict and a lot of human rights abuses in the Eastern Democratic Republic of the Congo. By imposing due diligence requirements and disclosure requirements on issuers that rely on 3TG in their products. And this will affect a very broad swath of industries, from aerospace and automotive to heavy manufacturing, high tech, and so on. Thousands of issuers will be affected by these new rules at a compliance cost that even the SEC is estimating in the billions of dollars. And many are wondering, I think even the SEC, whether these rules are really good tools to effectively deliver the social benefits that they target. The SEC's also acknowledged that the compliance requirements they impose are burdensome, that the costs are substantial, and that the benefits really can't readily be quantified. Both statutory provisions and the SEC rules have been challenged this fall in D.C. federal courts in a model that's similar to challenges we've seen brought already to other SEC and CFTC rulemaking under the Dodd-Frank Act. In the meantime, pending the conclusion of these legal challenges, a number of companies are left uncertain about what they're required to do, and perhaps feeling tempted to just wait and see what the outcome of the litigation will be. We have a knowledgeable panel here to address these issues from different perspectives. Rob Schwartz, on my far left, is an assistant general counsel for litigation at the Commodity Futures Trading Commission. Rob is the CFTC's team lead in the Investment Company Institute v. CFTC matter, in which the commission is defending against a challenge by the mutual fund industry and the U.S. Chamber of Commerce to regulations designed to implement Dodd-Frank by requiring certain investment companies that trade in swaps and derivatives to register and report financial information. He's also the CFTC's primary litigator in the MF Global Inc. bankruptcy proceedings, in which parties have challenged other CFTC rulemaking. Mara Sen, here in the middle, is a partner in Arnold & Porter's Washington, D.C. office. She advises clients on compliance with conflict minerals regulations. She's written about both the conflict minerals regulations and the extractive industry issuer requirements that we'll be discussing today, and has represented mining companies on a variety of issues. Her practice also focuses on the U.S. Foreign Corrupt Practices Act and on other anti-corruption laws around the world. She appears before the SEC, the Department of Justice, and other enforcement agencies on behalf of her clients. Veronica Kohler, to my immediate left, is the Director of International Policy at the National Mining Association. where she leads the association's engagement on international issues that affect the members' operations, whether domestic or foreign. She comes to us with a very unique set of experiences in the mining sector, and I think a unique perspective on the impact that these rules or that mining has on development. She joined the National Mining Association in 2010 after having spent 5 years at the World Bank in the Sustainable Energy, Gas, Oil, and Mining Policy Division. While at the bank, she worked on mining projects, mostly in Africa, including in the DRC and in surrounding countries, but also in Central and South America and in Asia, and on overarching global issues impacting the mining sector and affected communities. Veronica also managed daily operations of the Communities and Artisanal and Small-Scale Mining Secretariat. So, assuming that there would be varying degrees of familiarity with the rules that we're talking about today, I've asked our panelists to start by just giving a brief overview of what they require. And we'll start with Rob, who is going to give us an overview of the extractive issuer disclosure requirements.
Right. Thank you very much, Brady. And I apologize for feeding you that run-on sentence in the middle of my bio there. I wasn't sure if you were going to make it to the end on one forever, but you did well. Thank you. As you might gather from my bio, my expertise is more in administrative law than it is specifically in mineral and mining regulations that, whether the CFTCs or otherwise. So I'm going to cheat off of a fact sheet that the SEC has published explaining what the resource extraction regulations require. You typically would want to go directly to the regulation or the statute, but this one appears to be pretty accurate, so that's what I'm going to use to cheat off of. So obviously the regulations require disclosure of certain payments made to foreign governments or the federal government by resource extraction issuers. So the rules have several features. They start off by explaining who is covered. They require a resource extraction issuer to disclose payments made to governments if the issuer is required to file an annual report with the SEC and the issuer engages in commercial development of oil, natural gas, or minerals. The regulations then go on to explain what must be disclosed. These issuers need to disclose payments that are first made to further the commercial development of oil, natural gas, or minerals, that are not de minimis, and that are within the types of payments that the rules specify. The rules define not de minimis to mean any payment that equals or exceeds $100,000 during the most recent fiscal year, and the types of payments that must be disclosed include taxes, royalties, fees, production entitlements, bonuses, dividends, and infrastructure improvements. The rules require a resource extraction issuers to provide information concerning the type and total amount of payments made for each project, the type and total amount of payments made to each government, the total amount of payments by category, the currency used, the financial period in which the payments were made, the business segment of the resource extraction issuer that made the payments, the government that received the payments and the country in which the government is located, and the project of the resource extraction issuer to which the payments relate. The rules leave the term project undefined. The rules also specify how this information is to be disclosed. They require the resource extraction issuer to file a new form called Form SD on EDGAR. And it also specifies when it must be disclosed, and the timetable is no later than 150 days after the end of the issuer's fiscal year.
Great, thank you, Rob. And I think Veronica was going to give us an overview of the conflict minerals requirements.
Sure. Let me just mention I've been battling losing my voice the past couple of days, so please let me know if you do not hear me, and I will try to step it up for this hour and then not have the voice for the rest of the week. I wanted to start out with saying NMA, the National Mining Association, has not joined any of the two lawsuits that we will be discussing today, but so I'm here to provide the mining sector's perspective on 1502 and 1504, which we'll do so in the next two sections. But to summarize 1502, it is human rights violations and funding of armed conflict, where the conflict minerals might be doing such in the supply chain. Now again, these are informal supply chains. So the issuers, the prescribed persons for 1502 are manufacturers. End-use manufacturers are now required to link up their supply chains if they have in their end-use products tin, tantalum, tungsten, or gold, which we call the 3 T's and G. They are required to link up their supply chain to ensure that if the 3 T's or G's that are in their final project originated in or around DRC, that they did not fund human rights violations or armed conflict. And so the first requirement is to identify if you have the 3 T's or G in your final product, then to do a country of origin inquiry, which is a report where you try to link up that supply chain and see where you end up if the origin is DRC, in and around DRC. And then to work with that supply chain to see if it is part of that formal supply chain and it could or would have participated in funding human rights violations or armed conflict. Manufacturers, as some of the companies that that Brittany mentioned, are faced with an overarching challenge of tiers, supply chains that are 10,000 tiers deep. And what does an end-use manufacturer do with linking up that supply chain that they aren't even aware of who is in that supply chain? So the bottlenecks that we see from the outside are really going upstream from end-use manufacturer to the refinery that refines or smelts the 3 T's or gold. We see that as a potential bottleneck, and then a bottleneck upstream from that area to the source of origin, the actual mine. So there are many programs on the ground working to facilitate, help manufacturing companies to link up that supply chain, and it will be up to the manufacturers to decide which of those they choose to utilize and then report on their website. So the goal for 1502 is really to provide visibility and information to company clients and to donors to that company and to the shareholders to that company if any of their products contain the 3 T's and gold, and if they funded human rights violations. So at the end of 1502, it's really a report that you would be providing the board and putting on your website to show the due diligence that you underwent to make sure that your products, or anything included in that product, did not fund any human rights violations. One thing that companies have been concerned about, more so than just linking up that supply chain, which is understandably going to be difficult, is the contract to manufacture part of 1502. There's been some confusion around what does that mean. SEC mentioned that is the degree of influence that you exert over the manufacturing of a certain product, but that's an issue that manufacturers and companies are having, that they are looking for guidance.
Thanks for that overview. And as I think Veronica hinted, there are a number of complex interpretive complexities in the statute, as well as some compliance challenges that we'll be touching on later. And for that reason, I think a lot of companies might be asking, why do I really need to do this? And what happens, frankly, if I don't? What are the liability risks under these provisions, Mara?
Well, I mean, in theory, the SEC could go after you for not filing a required report. It's very rare, but it could happen. And if you don't have any qualifying conflict minerals, you actually don't have to file a report. So it's a little confusing because not every issuer is going to have to file a report. The other thing is under Section 18 of the Exchange Act, which issuers will be subject to because they are required to file as opposed to furnish their report. They can actually be sued not only for false statements, but they can also be sued for omissions. So somebody could sue them saying, we're harmed by the fact that we don't know enough information about that. So those are two potential liabilities.
Okay. Now, the extractive issuer disclosure requirements have, as we indicated, been challenged this fall in federal court filings in October by the American Petroleum Institute, Chamber of Commerce, Independent Petroleum Association of America, and the National Foreign Trade Council. And Mara, perhaps you could identify for us the key grounds of the legal challenge to the extractive issuer regime.
Sure. There have been two very interesting new trends that are going through the courts in relation to these challenges. One is actually a First Amendment issue. These are raised in both of the cases. There's something called compelled commercial speech, And it's a new issue. It's sort of an emerging issue in First Amendment. But essentially, the question is whether or not you can force a company to compel them to say something that will harm themselves. So, for example, recently, just within the last few months, the D.C. Circuit struck down a requirement by the FDA that tobacco companies put very graphic images on their ads because they said that's compelled speech that will harm the company. So one of the grounds in the challenge to 1504 is that the 1504 would violate the First Amendment rights of the issuers because by disclosing this information, they would be harmed in a variety of ways, including things like disclosing competitive information that will put them at a disadvantage, requiring them potentially to violate local disclosure laws, which would require them to pay more money, or contractual provisions for confidentiality. Some countries or companies in the local countries would not want to deal with them because they know any payments they make will be disclosed, so it might be that they would lose business in that way. So there's a variety of bases for asserting that there would be a harm caused by this compelled speech. And the FDA case that was just issued in, I think, August of this year actually directly conflicts with the Sixth Circuit case on the same exact issue. So it's very possible that the Supreme Court will take up this issue at some point, if not immediately, but it's sort of trending in that direction. The other sort of big category is a challenge under the APA, the Administrative Procedure Act, saying that these provisions are arbitrary and capricious. Again, there's been a shift because back in the day, courts tended to defer quite a bit to government agencies. Recently, in a number of cases against the SEC and the CFTC, the courts have said it is arbitrary and capricious for the SEC not to fully consider the costs and benefits. So they'll defer to the SEC on areas where they have expertise, evaluation of some sort of high-tech or complicated financial instrument that the SEC may have evaluated, but they will not defer to them less and less now on issues of evaluating what the competitive effect, the costs, and also the benefits. And as Brittany said, it's not even clear that there are benefits of these provisions, but there's definitely costs. So they, specifically in 1504, they have challenged a number of things. One is the Extractive Industry Transparency Initiative is a global initiative starting I think in 2002, which basically required companies and countries. The genesis is by the country. So a country adopts EITI, and then they require extractive companies that work in their countries to disclose payments they made to the government. The government then discloses the payments they receive, and the idea is to allow civil society to essentially evaluate that and be in the process enough to challenge if there's corruption or other kinds of problems. The statute that in Dodd-Frank said that basically the statute should be read to be consistent with EITI unless it clearly deviated. So one challenge is that they say that by requiring them to supply public information, because a lot of EITI submissions are actually confidential, and also by requiring them to provide broken out payment by payment information, that's arbitrary and capricious because under the EITI, typically you only have to give aggregate amounts and you don't have to break it down in all the different ways that Rob said, by payment, by government agency, on and on and on. You don't have to do any of that in EITI. So they're saying it's arbitrary and capricious. They did not interpret the statute correctly. They also say that it's arbitrary and capricious because they fail to define what project is. Is a project a huge, just the mine, or is it a subset of the mine? It's very difficult to figure that out. They also said that it's arbitrary and capricious because there's no exemption for foreign law violations of laws that prevent disclosure. So in many statutes, it'll say, unless otherwise provided by local law or something like that. In this case, there are going to be many situations where companies are actually going to be affirmatively required to violate the law. Like if the law says you are not allowed to disclose any terms of any government contracts, for example. Under this, they are affirmatively required to by the SEC, so they're going to have to choose between violating the requirements of 1504 or the foreign law. They also say that it's arbitrary and capricious by unfairly imposing a burden on competition for the issues that I just spoke about a little bit earlier. And then this one is the significant one, and this is the one that is similar to a lot of the other recent holdings striking down regulations, which is this arbitrary and capricious because they didn't do a sufficient evaluation of the costs and benefits. They did have I think it was like they estimated it would be 71 million initially. Then they got all the feedback where everybody said, are you kidding? It's going to be so much more. And they raised it to 3 to 4 billion. And then the final one, which quite honestly kind of looks like a throwaway to me, but it says arbitrary and capricious for not allowing additional comments after issuing final cost and benefit analysis. So, but glad they got that in. The other thing to note is that the plaintiffs in this suit also submitted a motion to the SEC in late October asking the SEC to stay this regulation until this case could be resolved, and the SEC in November said, yeah, we're not going to do that. So.
Okay. And Veronica, you indicated that the National Mining Association is not part of the litigation, so we'll emphasize that. But that being said, your members, mining companies, are certainly subject to 1504's requirements, and so perhaps you could give us a bit of a perspective from the mining sector on these requirements and on the litigation challenge.
Sure. The mining sector is supportive of transparency and disclosure of payments. Many of our companies operate in, as Mara mentioned, EITI compliant countries, the Extractive Industry Transparency Initiative. So many of our companies are used to disclosing and already have the mechanisms in place to disclose. And so our concern, the comments that we filed with the SEC on 1504 revolved mostly around let's minimize unintended consequences. Let's not make this overly burdensome. Not have there be duplicative requirements then and disclosure requirements, and not have the rules be too prescriptive. For example, the definition of projects, as Maura mentioned, and thresholds as well, de minimis, what level we're talking about, how close to the ground are we talking about. The EITI happens in countries where they're really trying to focus on reducing corruption and therefore increase transparency. The United States has a robust financial reporting mechanism as opposed to other EITI countries. And so we really thought, why don't we take this opportunity to streamline our reporting mechanisms in the United States, because we're not focusing on transparency for reduction of corruption, but let's focus on transparency to streamline, to reduce the reporting requirements, or at least to have them be working together so that they don't unnecessarily increase the burden on industry. Are the concerns were that the origins of 1504 were probably to gain visibility in countries that have not signed on to EITI, because 1504 requires domestic and foreign disclosure of payments, whereas EITI only requires that country to disclose payments within that country. So, which is another reason why we wanted to focus on streamlining and using the current robust mechanisms that we have in place. Our company is operating in EITI compliant countries. They are committed, and now that U.S. has committed to being an EITI compliant country, that's also then there's an overlap between what's going to be required for 1504, what will be required for EITI. We don't know that yet because the multi-stakeholder group makes those decisions, but we want to make sure that they work together and move forward in alignment, which we think there might be an issue with just because there are two different governmental departments that are focusing on them and will be facilitating their progression.
The multi-stakeholder group, that's basically the OECD, right?
The multi-stakeholder, each country that signs on to EITI defines for themselves who will comprise of their multi-stakeholder group, their MSG, or their board, or it's the entity that defines for that country what payments will be included, what extractive issuers will be included. So SEC identified for 1504 what is included by that with that list. That has not been identified for EITI yet. And so we have two disclosure initiatives moving forward, and we have to make sure that they're somehow working together so we don't now increase our reporting requirements just by 1504, but then double them by creating another reporting mechanism that's on transparency as well.
Great, thanks, Veronica. And Rob, as someone who's helped the CFTC try to defend challenges to some of its rulemaking under Dodd-Frank, what can you tell us about the SEC's likely defense of this rule?
Yeah. Well, before I begin to speculate, I guess I'm required to say that nothing I say represents the views of the CFTC or the General Counsel. To repeat my quip on the phone with you guys, I don't know why anybody in that context would be particularly interested in what I had to say about that, but here goes. The First Amendment challenge is very interesting. Not only the fact that there is a split in the circuits and it's not clear how that would be resolved even in the context of what needs to be disclosed in packaging a tobacco product. The SEC regime is based on disclosure, so it's hard to see where the end of that argument would be if a First Amendment argument was successful in this context. I take it that most of what the SEC requires that issuers disclose is not information that they would otherwise prefer to disclose to the extent it may not be favorable to the favorable information everybody wants to get out there as soon as possible, but the disclosure regime is that you must disclose true material information that is specified whether it's good for you or bad for you. So on a number of levels, it'll be interesting to see, A, if the Supreme Court resolves that split and how it does it, and B, even so, how any holding in that regard could be translated into the securities disclosure context. With respect to the claims that the rulemaking is arbitrary and capricious, this rule differs from a lot of Dodd-Frank rules in how prescriptive the statute is. So I imagine that, and this is throughout the rule release, I would expect the SEC to defend largely on the grounds that Congress required them to do most of what they're doing here, and that has a couple of applications. The plaintiffs contend that the SEC misunderstood the mandate, particularly with respect to what must be disclosed publicly as opposed to just submitted to the SEC. The statute says that the Commission shall make available online to the public a compilation of the information they obtain. And the complaint recites that Section 1504 requires only that a compilation, which they say is a synonym of aggregation of payment information, to be made publicly available. The thing about that is that's not what the word compilation means. Compilation means a compiled set of data. Now, the SEC didn't really push back in that way in the final rule release. They talk more about the purpose of the statute and how the purpose is to get this sort of information out into the public so that foreign governments will be accountable. So it'll be interesting also to see how that plays out in the litigation and how they choose to argue it. The fact that much of the final rule is required by the statute also affects the consideration of costs and benefits. The statute that requires the SEC to consider costs and benefits requires the SEC to consider the economic impact of its own actions. The SEC's discussion of this in the release is extensive, and it goes to some extent further than the statute requires, in that there's extensive discussion of what the costs are of the statutory requirements themselves. Now, to some extent, they have to do that in order to establish a baseline to evaluate what their own regulatory choices cost. But it may render irrelevant the criticisms of the number that the SEC has come up with in terms of what the statute will require, whether it is 71 million or into the tens of billions, like some of the commenters suggested. It may boil down more to whether they got their own costs of their own regulatory choices right. But this is a wide open area of law. Obviously, there have been these several cases. All of them have been on sort of idiosyncratic laws, and it's hard to get. It's hard to state any general principles for what your cost-benefit analysis must look like. It's hard to derive that from the cases. So that I think anybody from the SEC would tell you is their real vulnerability because of how the cases have gone, and because the D.C. Circuit has said some things that are difficult to apply going forward to protect yourself as an agency. For example, the Business Roundtable decision had a lot of negative things to say about the SEC's cost-benefit analysis in that case, but one of them was that it relied on a study that was, quote, relatively unpersuasive. So, I don't know what an agency is to do if the D.C. Circuit is going to evaluate your rulemaking in that way. So, it's an interesting opportunity for the courts to further elaborate what may be required generally in the context of the SEC statutes and by extension, some of the other agency statutes that require similar things.
And what can we expect in terms of a time frame for resolution on this? And any sense, anyone willing to venture any predictions on an outcome on this challenge?
Well, I mean, at least as to the 1504 challenge, they actually filed it in both the D.C. District Court and the D.C. Court of Appeals, Circuit Court of Appeals, and they're currently litigating which venue it should be in. So it's not even to the point of talking about merits. The same thing happened in the CFTC case. So if you take the CFTC case, that's been going on for about a year, plus it's currently up on appeal, which is, they did the same thing where they said, should it be in the D.C. District Court or should it be in the Circuit Court? They decided it should be in the Circuit Court, which actually both parties agreed on in this case, and I think in the other case as well. But they just wanted a ruling so that they weren't, wondering where it would be. So in terms of timing, I mean, this case, I'm guessing, will take, a year plus, both sides will likely appeal regardless of the outcome. So I think it'll be a while. And I agree with Rob. I mean, this is really, it's breaking new ground all the time. I think a lot of it in the D.C. Circuit in particular will depend on who the panel is, because I mean, in one of the cases it was Ginsburg and Santel, I think, which is two very, very conservative members of the D.C. Circuit. I think if they had drawn a different panel, it might have been a different outcome. Because as Rob says, I mean, what this is, this whole First Amendment and arbitrary and capricious litigation is it's really an attempt by the business community, or maybe the conservative wing of the legal community, to essentially try to roll back regulation. I mean, it's really a policy decision, and it's a strategy that they're using these tools. And at a certain point, if you take it to its logical extension, there can be no more regulations, because you can't have somebody spending years and years and years on a cost-benefit analysis and then have the courts come in and second-guess them constantly. I mean, you can, but that just grinds all regulation to a halt, which, for some of these entities is what they want to have happen. And same thing with the First Amendment. I mean, if you can't, the companies in the SEC situation, they are getting something. I mean, they're allowed to be filers, they're being regulated, they're recognized throughout the world as complying with SEC regulations. And, if the SEC can no longer compel them to say something that they don't like, I mean, that affects not only the SEC, but also every other regulation where it says, you're getting a benefit from the government in exchange. If you want to have this, if you want to fall into this category, you must give us this information. And if you take the First Amendment challenges to their logical extremes, a lot of compelled commercial speech will be against their interests, and that's sort of the give and take with government and the kind of governmental contract.
Can I ask a question on the First Amendment argument? Is the argument literally you can't compel a business to speak out against itself, period, or is it a tailoring question?
Well, it's actually in the R.J. Reynolds case, the district court, it's a First Amendment, different kinds of scrutiny, and one of the big questions is what level of scrutiny will it be. So the district court in the R.J. Reynolds case said it was strict scrutiny, and then the D.C. Circuit said it was intermediate scrutiny. So that's going to be one of the issues is the level of scrutiny that you can give and the level of deference. I mean, that will be obviously the
But there's
key.
not a notion of there's some absolute right against compelled commercials.
No, because this is there's only been a very few cases ever even on this situation, because there used to be compelled, there used to be commercial speech, and how can you do advertisement and things like that, and that was one line, and then they had compelled speech, like could you compel somebody to say something that was political, and so this is sort of the joining of two different lines, and so there have been not very many cases. I don't know that there have been more than a couple on this area, so it's it really is pretty wide open.
And following up on one of your points in terms of whether rulemaking would ground to a halt and so on, what's your take? And I'd be interested in yours, Rob, as well, on the comedy argument that I think was made, which was that if other countries' laws are actually prohibiting this sort of disclosure, then the SEC should be trying to enact rules that avoid, to the extent possible, that sort of direct head-to-head conflict with foreign laws.
The SEC dealt with this in the final rule release, I thought, pretty persuasively. They had commenters on both sides. Some of them said foreign laws do prohibit you from disclosing this information. Others said foreign laws don't prohibit you from disclosing this information. It doesn't seem like the SEC really concluded one way or another, and it's hard to know how they would be able to draw that kind of conclusion. But they reasoned that if there are such laws, or even if there aren't such laws, if there were an exception like that, it would be an inducement for foreign governments to create such laws. So it would really be kind of a self-defeating way of amending the regulation.
Okay, and Maura, for companies who are thinking about taking a wait-and-see approach, given the pending litigation, waiting to see what the outcome of that might be, what would your recommendations be?
Well, it sort of depends on where you are in your systems. I think 60 large oil and gas companies and mining companies have already signed on to EITI, so they're already have these payments, at least in some form, ready in their systems. If all it is a question of, hitting a button and all the information they need is right there and they can just print it out, then obviously they're not going to need very much lead time to comply. If, on the other hand, they have gathered a lot of the information, but because EITI is structured differently in the countries where they operate, it might be that 1504 requires them to add a huge amount of new information. So if they don't have the breakdown already, I think it's difficult to say that they should stop looking into this, at least, and evaluating how long it would take to comply, because basically anytime your fiscal year ends after September 30th, 2013, plus 150 days. So that would be like, let's say it ended in October 2013. That's about 5 months. So November, December, January, February, March. So March 2014. And having dealt with companies a lot of times where you sort of try to find information that you would think they may already have, they absolutely do not have it. And it will take, very, very much work to find that information and supplement the information, like, who's the agency, the currency should already be in there. But, it could take a lot of time. So the companies really have to evaluate how much effort it's going to take for them to be in a position where they can be compliant. And depending on where they are, and given the timeline, and given the uncertainty of when this case would end. Because, if we're at the end of 2012, and if it takes as long as the CFTC, it could be the end of 2013 before it even goes up on appeal. And so, you're starting to get pretty close to the time where they would have to decide whether to comply or not. And the SEC has already said we are not suspending the enforcement of this rule. So, I think it's an individualized assessment, but they just, given that timing, they have to assess for their own company sort of where they are.
Okay. And I think you've highlighted there's some of the compliance challenges that companies who want to implement this rule are going to face. Before moving on to talking about conflict minerals, is there anything that you'd want to add on that, Veronica, from the perspective of the mining sector? Compliance challenges or unintended consequences of the rule?
I think the compliance challenges are really the de minimis threshold that I mentioned before. Being 100,000 is very small. And so while many of our companies are already complying with many types of EITI requirements, and therefore we think it could be fluid movement into 1504, it depends on what those requirements are in each of those countries. And the $100,000 threshold is very low, and it's not something that many companies are tracking currently. And so the impact to then go over all of your projects and to track from the beginning those payments. And it's also, as Rob mentioned, aggregate payments of 100,000. So you're tracking payments that are actually less than 100,000. So that is where the issue comes in for compliance costs and actually compliance challenges. The other issue was the definition of projects, and SEC ended up including into the rules that there would be some leeway on that and leave it up to the SEC issuer to identify what project means for them, which is something that would benefit industry in allowing them to respond, because hopefully they will be able to use the definitions of projects that they already have in place, not prescriptive to how SEC feels the project should be defined.
Yeah, and one other thing that I think is very interesting and will happen a lot in oil and gas and mining is that what if you're in a JV with 3 other companies and only one of you is an issuer? So the rule in the SEC is basically if you control the JV, then you have to file. If you don't control the JV, you don't have to file. Well, in a lot of these cases, the JV board has everybody equally divided, but maybe one of them has a CEO. So I mean, it's going to be, it has to be a fact-based case-by-case analysis. But obviously, the non-issuers are probably going to not want to disclose, and the issuers may feel like they're obligated to disclose, but would have to convince their JV partners. So I think that's an area that will be very difficult for the companies to work out, but also a very interesting area.
So changing gears, if we could, a bit to the conflict minerals requirements. These have also been challenged in federal district court here in D.C. this fall, this time by the National Association of Manufacturers, the Business Roundtable, and the U.S. Chamber of Commerce. Mara, recognizing that briefs have not been filed in this case yet, what can we glean about the key arguments here?
Sure. I mean, they sort of follow the same pattern as 1504 and some of the other cases, which is they have arbitrary and capricious arguments and then a First Amendment argument. One of the arguments is that they say that it's arbitrary and capricious to refuse to adopt a de minimis standard. So, in other words, the SEC decided, and this was discussed a lot in the comments, that any amount of conflict minerals could bring you under the rubric of the regulations. So people would say, well, if it's just a coating or if it's just really tiny milligram of gold, why should that be in the regs? I assume that the reason is because a lot of times, like for example, in microchips and things like that, you have a tiny amount of gold, and so if you put a de minimis standard, that would exclude a lot of the electronics manufacturers who are one of the core people who are participants. So that's one of the arbitrary and capricious challenges. The other one, which is interesting, and it's an issue about relating to the difference between what Congress said and what the regulations say. That the actual law says conflict minerals are necessary to the functionality or production of a product manufactured by such person. And what they said in the regulation is that that it's okay if you contract to manufacture, which is different than manufactured by that person. And that's as Veronica mentioned, that's a huge area. I mean, contract to manufacture is probably the biggest area of contention because there are all these people like retailers who, say we need you to manufacture this good for us or that good for us. They're not doing the manufacturing, but they're certainly contracting to manufacture goods that contain metal. So if they win on that point alone, that would have a huge impact on compliance because huge numbers of companies would just simply drop out. The other thing that they challenge is the reasonable country of inquiry challenge requirement. So basically, if somebody identifies that they have the 3 Gs and T or T in their products, they have to do a reasonable inquiry to see if they can figure out where that metal is from. And the statute actually says that the statute says what you have to look into whether it did originate in the Democratic Republic of Congo or adjoining countries, and in cases in which such conflict minerals did originate in any such country, blah, blah, blah. In the regulation, it says reason to believe that it may have originated. So again, that broadens the mandate from Congress quite a bit. So that's an area where they also challenged it. They also say that it's that the transition period, they didn't really explain why, but the transition period, basically for 2 years, you can say, we don't really have any idea where this is from. And they say that's arbitrary and capricious. And then they also, without explaining very much, wanted to also was talking about violating First Amendment as compelled commercial speech, which I think is a little bit less compelling in this case because it's not really a normative law. 1502 is really just a disclosure law. They could have impacts from the public saying, well, why does your product contain this or that conflict mineral? Because I mean, it's very, under the rules, it's perfectly acceptable for the companies to say, by the way, I'm a gold manufacturer. All I do is manufacture gold jewelry, and all of it is from the DRC. I mean, as long as they disclose that, that's fine. But it's obviously against their interest to disclose. And back to your question, Alex, I actually have written down what the D.C. Circuit said about the standard. It says, the First Amendment requires the government not only to state a substantial interest in justifying a regulation on commercial speech, but also to show that its regulation directly advances that goal. So it has to be, and of course the interaction between how closely they have to, reach that goal has to do with the standard applied and things like that. So they also have a First Amendment challenge, so that'll be interesting to watch.
Which court is that in, and at what stage is that?
This actually, they brought it just directly into the D.C. Circuit. They didn't bother with the district court. I think they sort of figured, since there were a couple other rulings that said so. And actually, interestingly, they have an expedited. Both parties agreed to have an expedited briefing schedule. So right now, the substantive briefing is supposed to end in March of 2013. The other interesting thing, which I just heard the other day, is that I knew this part for a while. The SEC is actually seriously considering, and I assume that they absolutely are going to, although they won't confirm it, issuing additional details for the regulations for 1502. So they're working on hypotheticals and a variety of other things to clarify, because as I like to say, that in my mind, most of the regulation for 1502 is almost content free. I mean, it says things like, we are not going to define what contract to manufacture is because we think everyone knows what that means. We are not going to find X, Y, and Z because we think everybody knows what that means. And all the companies are like scratching their heads saying, well, we actually have no idea what it means. But apparently, because of this case, I thought it would have been the opposite. I mean, I thought that the SEC should have issued that regulation before this case was over to say, look, we just clarified everything. We're all fine, et cetera, et cetera. Instead, I guess they took the opposite view, which is also perfectly legitimate, that they don't want to mess with the administrative record and open potentially other issues. So apparently they're going to hold off on issuing any explanatory additional regulations until after at least the briefing and possibly the ruling, which of course will push back efforts to comply even more. So, it's sort of a jigsaw puzzle.
Well, that's an interesting point, since the reporting period for 2013 begins January 1st, 2013. Right. So what does that mean as a practical matter for companies who are grappling with whether and how to comply in light of this challenge?
I mean, I think that companies just have to put into place, the people who they're going to give ownership of this process to, start figuring out how they're going to, the process, and basically put everything in place. They can't even do, I think it's really hard to do questionnaires even, because if they drop part of this to their suppliers, if they drop part of these requirements, they might not need to know. Or conversely, if the SEC issues something and says, oh, by the way, in order for due diligence to be adequate, you have to do the following 8 things, and someone's already deep into their due diligence and they've done 5 of those 8 things, I mean, they're going to have to go back and do 3 additional things. So I think what companies have to do is they have to gather all the information, figure out, who their suppliers are, make sure they have a comprehensive list and are ready to drop as soon as this information comes out. And one tricky thing is, if the suppliers change, like the suppliers, they drop the suppliers or they add a supplier, I mean, they have to keep track of that. But basically be ready to go so that once this clarifying information comes out, they can actually start implementing. But they have to start really thinking. And for some companies, some of their products have conflict minerals and some of them don't. So they don't have to do due diligence on everything they make. So, and most companies, I mean, I would have thought that, like a bill of materials would include, it has 2%, cadmium, 2% lead, 2% tin. So all you have to do is look at this, bill of materials to say, oh, okay, well, this does or does not have the 3T and Gs. And, that's absolutely not how it works. So they actually, even just to see whether they comply, they have to go to their supplier. So, I mean, whether they fall within the rubric of the regulation. So it's a very complicated issue, and some would say impossible because of all the layers upstream from them on the supply chain. So,
thanks. And Rob, do you have anything to add in terms of SEC likely defense of these particular challenges?
I imagine we're going to see a lot of the same sorts of defenses in terms of, especially in terms of the cost-benefit issues. I think even maybe equally so to 1504. The issue comes up in both of these cases that the benefits that are sought to be achieved are inherently unquantifiable. And that's true of a lot of benefits that legislation and regulation hopes to achieve, whether it's achieving stability and transparency in financial markets, or stopping or at least stopping contributing to violence in another country. It's always going to be a lot easier to quantify the costs than it is going to be to quantify the benefits. The SEC statute doesn't require it to mathematically prove that in a monetized way the benefits of the regulation outweigh the costs that are going to be borne by the regulated entities. And the cases recognize that some costs are not quantifiable. And I think it's also fair to, on either side of the ledger in terms of costs or benefits, you can make an estimate, but sometimes there's enough variability in an estimate that it's just not useful. I think the SEC ought to be arguing for, these tend to be the older cases, but there are cases that talk about the discretion that an agency has when a statute doesn't specifically explain how to analyze issues like this. They ought to be arguing for a lot of discretion because the statute doesn't. It says that they have to consider these things, but then it doesn't go on to explain how that consideration is supposed to take place or how different factors are supposed to be weighed. So I imagine that we'll be seeing arguments like that. The de minimis exception is interesting too because they declined to give a de minimis exception primarily because they interpreted the statute to be inconsistent with a de minimis exception. The conflict mineral must be, quote, necessary to the functionality or production of the issuer's product. So I guess the argument may be that if it's a small enough amount of this stuff, then it wouldn't meet the test of necessary to the functionality or production of the product. That may be one that they would argue for Chevron deference on. So that's we'll see if that's an arbitrary and capricious issue or if it's an issue that they're entitled to more deference on.
Okay, and Veronica, recognizing that, again, the mining sector is not part of this challenge, and in fact, mining companies in the final rule were actually carved out, that mining issuers are not required to make disclosures under the rule, though they'll undoubtedly receive due diligence requests as part of the supply chain process and inquiries. What's the mining sector's perspective? What can you share with us about the mining sector perspective on both the legal challenge that's being brought and also your views on some of the compliance challenges that are likely to be faced?
Well, I think at the 10,000 foot level, we're not sure if it will achieve the goals that it set out to do. And so it might, while it's raising visibility in and around DRC, which is good for improving the situation on the ground, it may have been more important to ensure the procedures or applications were available on the ground for companies to be able to respond and link up their supply chains before they're mandated to do so. The human rights violations, they're coming from as I mentioned before, the informal supply chain. And so that it was appropriate for the SEC to exclude mining from the definition of manufacturing, because the SEC issuers, the extractive industry SEC issuers, are operating on the ground in and around DRC. That's the formal supply chain, that's the formal mining sector, and are having real positive impacts on the ground in DRC and many mineral resource-rich developing countries. Katanga is actually the most stable and peaceful region of DRC, and it's because there's formal mining there, Freeport, McMurrin, copper, and gold. And so to, again, put duplicative or overly burdensome rules on the mining sector when they are actually having the impacts and achieving the goals that 1502 is trying to achieve in the region, why would you then create these burdensome rules for them, while they will be participating in linking up that supply chain, because they are the formal supply chain, and many of them have integrated supply chains, and so they'll be responding to requests that trickle down from the supply chain of the manufacturers, and so we'll be participating in 1502, but we think it was appropriate for SEC to exclude them from that definition of manufacturing that Mara mentioned was a bit humorous, that they said they will not define it because there's a general understanding of the definition, but then went ahead to potentially define it in a way that includes industries that one would not expect to be included. Compliance, it will be challenging for the manufacturing industry to link up that supply chain. Our sector sometimes, as I mentioned, has that integrated supply chain, and so own a product all the way up to a smelter or refinery. That will minimize some of those bottlenecking issues. But again, the reason there's a 1502 is because of the human rights violations and supporting of armed conflict that is coming from that informal supply chain. And it's important that we make sure that it does negatively impact the communities that are operating in that country. It's their only opportunity for income generation or livelihood. And maybe the key would be to formalize those supply chains and to build infrastructure and capacity within the government of DRC, which is what a lot of the civilians from DRC mentioned in the financial services hearing discussing 1502, that maybe by 1502 this is really trying to put a Band-Aid on a symptom and not really dealing with the overarching issue, which would be to help build stability within the government and to build infrastructure within the government, which is what the formal mining sector is doing on the ground. So we're supportive of, moving forward in a positive way, issues that are happening in DRC and surrounding countries, and we'll be participating in linking up those supply chains as we can.
A number of companies have been out ahead of the rule in a way, in starting to try to implement due diligence procedures like the OECD framework, for example, within their supply chains, and have encountered some challenges in that process that could shed light on what companies are going to face who are just starting the process. What can you tell us about some of the key compliance challenges that companies face in this area?
Yeah, I mean, if you think about it, let's say you're a retailer and you're buying, they excluded Walmart and the other big box stores were able to get an exclusion. So if they just buy something literally off the shelf and slap their brand on it, it's not part of the regulations. But for other retailers where they actually ask for, specific products built to spec, and they, have some control over it and arguably contract to manufacture, they deal with the vendor. So let's say they have a vendor in China, and then the China vendor is dealing with the factory, and the factory is getting some of their inputs, whether it's raw materials or specific small parts or whatever it is, from other people, and then so on back and back. So you're the end point retailer. I mean, you're just taking your stuff and putting it in a store. You have a relationship with that vendor, but maybe that vendor, it speaks only Chinese, and you have one person in your office that speaks Chinese and deals with that vendor. So then you send the vendor and say, do you have tin, tantalum, tungsten, or gold in your products? And they say no. I mean, how do you verify that? How do you, and then you say, okay, well, can we contact the factory directly? And if that vendor won't help you contact the factory directly, or they say, yeah, sure, go ahead, and the factory says, well, who are you? Why do I care about what you think? I mean, you can see very quickly that a company who is trying their very best to get information is quickly going to end up with a pretty dead end. Not to mention cultural, challenges and language challenges, and how do you say tungsten in Chinese, and stuff like that. So I mean, just the sheer practicality of it is going to be very challenging. And then, I think a lot of companies are also grappling with, like I said, this is really not a prescriptive law; it's a disclosure law. So companies have to grapple with, well, now that I have to disclose this, do we really want it to be a company policy that we're going to have our whole entire supply chain conflict free? Because if they say that to the market, and then these people who are complete unknown entities turn out that they're lying to them, and then it turns out there's an expose by 60 Minutes that says, haha, we found in your supply chain there's actually all this tin from the Congo, they're going to be in a lot of trouble. So people are grappling, I think, with should they prescriptively prevent that in their company, and then they're sort of taking on additional obligations than what they need to under the law, and that could expose them to some unwanted liability. So just from the very small, very basic logistical issues all the way up to big policy issues, I think it's a very, very challenging statute for companies to implement.
And even if they get a no back, or something, if they make it an I don't know back, or they may get nothing back, I mean, there's been some issue of supplier fatigue, getting a number of inquiries from a lot of companies, and they're sort of tired answering, and then you're left with the verification issues even when they do respond, and so on. So a number of challenges. I mean, how do you avoid the unintended consequence of just pulling the trade away from the region altogether, which is obviously not what the rule intends to do? It seems like a number of companies are hoping to rely on some of the certified, conflict-free smelter type regimes that are developing, but that's slow in the making. There's a very small list of smelters that have made their way onto that list. So how do we avoid these unintended consequences?
Although I understand, I mean, besides gold, I understand that the smelters constitute a large percentage of the materials, so that the conflict-free smelters is a possibility. But I think that I think it's all of this stuff is very, very challenging for companies. It's a tough one. And then I was going to say, and then there's specific questions about well, if I go in and I ask some company to build me some kind of large machinery, and they have like 5 different things that I could put on or put off, does that make it contract to manufacture because I asked them to add a cab to the caboose or whatever? All those kinds of line drawing questions which the SEC has given. One really quite pathetic and unhelpful hypothetical about a cell phone. They're going to have to do a little bit better than that. Companies are going to draw those lines, but if the SEC wants them to draw them in a way that the SEC wants to have input into, then they should probably give a little bit more guidance, which is, I assume, what they're planning to do.
Okay. Well, before opening up the floor to questions, which I'd like to do, you talked a bit more about the possible liability avenues under these provisions. Do any of you have a view on the likely enforcement of these provisions? Is the SEC likely to be scrutinizing these filings and taking an interest if the requirements aren't met?
I think they're just going to be happy when the litigation is over. They probably.
I'm sort of more interested in whether they're and how successful private lawsuits would be in these areas, because typically a securities plaintiff has to prove that there was some difference in the price of the securities that resulted from misrepresentation. This is not information that was viewed as material before. So it'll be interesting to see if people are able to successfully enforce these privately in the courts. I don't know how it will work.
Yeah, and I think the other thing that will be interesting to watch is, the impetus for these laws really came from the NGO community in large part, and the human rights community, and they are going to have a huge incentive to use any tool that they possibly can to, enforce this more and get more more coverage of these issues. So I would actually think that I agree that there's not really much materiality, but I would guess that human rights organizations and NGOs are probably already thinking of ways that they can use litigation to further even more their priorities and try to use some of these tools that are granted by the requirement to file and other things that will allow them to prevail on certain issues that they're relating to this. And I think a lot of it will spin off from the outcomes of the litigations.
It seems like also the new whistleblower provisions are going to spark some of the enforcement, because most of these provisions can be worth a substantial amount of money.
I think also that this has gotten such high visibility, not just because of if you have 3 Ts or gold in your final product, but the mere fact that we are now identifying conflict minerals or creating something and putting a name of conflict mineral on it, that a process that companies have to comply with, anything can move in and out of this term conflict mineral. So it's not just about the 3 Ts and gold, it's any commodity now. And we're surrounded by them, and they keep us in the quality of life that we've been accustomed to being in. And so everybody should be concerned and participate in this process, because it's the 3 Ts and gold now, but it could virtually be anything as countries move in and out of the state of conflict, or commodities are perceived as participating in that level of conflict on any level.
Well, what questions do we have from anyone in the room? Sure.
I think you mentioned that 1502 has a required for manufacturer phrase in it, that it's not just an ingredient, but it also could be required for the manufacturer of the product. Would that include like tooling?
No. Okay. No, they exclude byproducts and tools are not. So if it creates, just as part of the process, something that's not used in the product, or if you use tools, tin or that have tin or tantalum or gold in them, that does not count. That is not part of the reg.
Good question. Other questions?
Well, one of you mentioned that, I guess the Dodd-Frank statute said that the regulations ought to follow the EITI unless, I forget sort of the exception clause, but what did the SEC say in its preamble about why it didn't, to the extent that it didn't?
Why it didn't follow?
In other words, where its rule diverges from EITI, what was its asserted justification for?
In part, where the statute seemed to indicate otherwise, right?
Right.
So if there was something specific in the statute that would suggest that Congress was looking for something other than what's normally in the EITI regime, that would be one reason.
That would seem to be a pretty good defense against an arbitrary capricious argument.
I don't know if there were others, but that's one I think I remember.
EITI is also, it's very general, it's very broad, it's an overarching framework. And so it mentioned to be as aligned with EITI as possible. It's really when one says that, it's really the principles that are associated with EITI, because for a EITI, it's the country that then decides what that means for that country. So EITI means many different things in the different countries that are EITI compliant, which is why it's interesting that U.S. signed on to become an EITI compliant country, and we are now in the process of defining for ourselves what EITI means, which is why we thought there would be a good opportunity for 1504 to really create some synergies with what the U.S. decides for U.S. EITI will mean for the United States, because 1504 SEC decides what the rules are going to be, but the framework, the EITI framework, it's a 3-part tripartite approach: government, civil society, and the extractive industries. They come together and decide what it's going to mean for that country. So they're all talking about transparency, but the process is very different to get to what actually will be required by that country. So 1504 the rules couldn't say much more, be more prescriptive along the lines of EITI, because it's different for every single country.
Look, so with EITI, excuse me, the government participates, correct? The government discloses the payments received, so 1504 wouldn't actually accomplish that. It can only, prescribe what the companies have to do. So it's not gonna. I'm guessing, they would like to get countries that aren't in EITI to somehow have to report, but it would be the companies. I mean, it's just
Yeah, I mean, it might increase pressure on those countries because now they're going to have, okay, let's say a mining company says, okay, I have a mine in Namibia and I have a mine in the Congo and I have a mine in Brazil. And now if one of those, I don't know, there are like 40 something countries that are on EITI, so I don't know all of them off the top of my head. But, if Brazil, let's say, hasn't signed on, they may have, you as a civil society person could then amalgamate all the public reports from Form SD and say to Brazil, look, of the filers that filed, you received $5 billion worth of payments. Therefore, we think, since that's a lot of money for Brazil, we think that you should therefore join the EITI so we can match it up. And one issue I think on EITI for my other practice, which is anti-corruption, is that the whole point of EITI is to see if there's a matchup between private sector and government reporting. Well, there are a million different ways that companies, cash accrual, or accrual, different, they can count their payments in different time periods. They can define a project differently. So you're going to have a situation in a lot of countries, and it's happened a couple times already, where the countries report, we received $50 million in year one, and the company said, okay, well, we paid $56 million. So now it looks like $6 million has gone missing. So if you're an anti-corruption enforcement person, you'd say, aha, there's $6 million that have gone missing. Maybe this is a corruption problem. We should launch an investigation. But of course, $6 million, it could be that, that those other payments were just in another time period, that the government, put them in another bucket for whatever reason. So, the EITI, while it has lofty goals and I think it's very good, there are also some unintended consequences as people get more sophisticated, as these things go online and can be interactive. I think we're going to see more, and of course we have a lot more international cooperation. I think we're going to see more, and as EITI advances, we're going to see more situations where there might be mistaken beliefs that corruption occurred when in fact it's just an accounting. That's why we need accounting.
And those are challenges just under EITI,
right?
Where you have both sides that are in theory reporting according to the same criteria. Exactly. Now you have a Dodd-Frank that gets at only one half of that, and it doesn't actually track EITI perfectly. And so how do you actually match that up, and what does it tell us? How does it increase the accountability?
Right, and there might be the same company who has to file 1504, plus they have to follow EITI in 5 different countries. And so now they have, their Brazil number is 55 million, but then for 1504 purposes, but for EITI purposes, it's actually, 48 million. And again, there are all kinds of securities issues that can arise as a result of that. So,
and to what extent have the international organizations reacted to Dodd-Frank? I mean, all the different entities from the UN has resolutions on conflict minerals. OECD has an initiative. World Bank has an anti-corruption initiative, and it funds a lot of these projects.
Right.
So you would think that all of those organizations, if they wanted to, could also tighten their rules to supplement what.
Well, I mean, I think the international, human rights organizations were disappointed that 1502 wasn't prescriptive, meaning you need to have conflict-free as opposed to just disclosure-based. So I'm sure, I know that they were, that's not exactly what they wanted, but I mean, it's a step in the right direction. And I mean, like the World Bank, for example, they have really picked up their anti-corruption enforcement a lot in the last couple of years. So so I think international organizations are doing this, but the key here, I think, is that EITI and a lot of these international conventions, they don't really have teeth. I mean, it says, it is the sense of the United States that we therefore sign on, and we will therefore, go for the most, moralistic, et cetera, and but it isn't. If you don't do it, I mean, nothing really happens to you. I mean, 1504 and 1502 at least is administered by an entity that has an enforcement record, and in theory, it has more teeth than some of these other initiatives. So I think that's for the international community who has support these initiatives, I think probably are happy to see that happen in the United States.
I just wanted to ask a question on the social benefits of 1502. I think we can all agree that there's really no way to quantify the social benefits, and maybe the agency couldn't be expected to do that. But I wonder if the agency has an obligation to at least confirm that there's a positive relationship between the law and its goal. And it seems like a unique situation here where there's this 2-year gap between passage of the law and the implementation of the regulation, where the available evidence suggests that there's no relationship or an adverse relationship because of a de facto embargo. But on the other hand, that relationship is implicit in the law. It kind of assumes that there will be benefits. So if the SEC says that there aren't benefits, are they second-guessing Congress in a way that they're not really allowed to do? So I don't know if there's any guidance in case law or if anyone wants to venture a guess, but...
Yeah, I think there's not, but I think it stands to reason that if Congress lays down a goal pretty explicitly, as it does in these cases in statutes, that the agency is entitled to, ought to assume that if it's at least logical that what they're doing could lead to the positive results that Congress is talking about, then that's I would think a court would find that persuasive, that Congress established a goal and a mechanism to achieve that goal, that if the agency kind of goes along with that, it ought to be in pretty good shape. The other thing that is in a lot of the give and take with the commenters is the same sort of, even without data, the kind of logical, here's what ought to happen if you tweak the rule in this way or that way. If there's not data available, I think the agency is within its authority to reason through it as best it can. And if it's not presented with contrary data, I don't think it has an obligation to sort of go out and manufacture data. The decisions have made pretty clear that an agency doesn't have to, for example, conduct a formal study to determine whether its goals will scientifically be achieved if it takes certain action. And it would be very difficult to do so with provisions like this.
Any other questions in the room? Any questions from anyone who's dialed in? Okay, well, thank you all for participating, and thanks to our panelists for your participation as well. As a source of funding for armed groups that are causing conflict and a lot of human rights abuses in the Eastern Democratic Republic of the Congo. By imposing due diligence requirements and disclosure requirements on issuers that rely on 3TG in their products. And this will affect a very broad swath of industries, from aerospace and automotive to heavy manufacturing, high tech, and so on. Thousands of issuers will be affected by these new rules at a compliance cost that even the SEC is estimating in the billions of dollars. And many are wondering, I think even the SEC, whether these rules are really good tools to effectively deliver the social benefits that they target. The SEC has also acknowledged that the compliance requirements they impose are burdensome, that the costs are substantial, and that the benefits really can't readily be quantified. Both statutory provisions and the SEC rules have been challenged this fall in DC federal courts in a model that's similar to challenges we've seen brought already to other SEC and CFTC rulemaking under the Dodd-Frank Act. In the meantime, pending the conclusion of these legal challenges, a number of companies are left uncertain about what they're required to do, and perhaps feeling tempted to just wait and see what the outcome of the litigation will be. We have a knowledgeable panel here to address these issues from different perspectives. Rob Schwartz, on my far left, is an assistant general counsel for litigation at the Commodity Futures Trading Commission. Rob is the CFTC's team lead in the Investment Company Institute v. CFTC matter, in which the commission is defending against a challenge by the mutual fund industry and the U.S. Chamber of Commerce to regulations designed to implement Dodd-Frank by requiring certain investment companies that trade in swaps and derivatives to register and report financial information. He's also the CFTC's primary litigator in the MF Global Inc. bankruptcy proceedings, in which parties have challenged other CFTC rulemaking. Mara Sen, here in the middle, is a partner in Arnold & Porter's Washington, D.C. office. She advises clients on compliance with conflict minerals regulations. She's written about both the conflict minerals regulations and the extractive industry issuer requirements that we'll be discussing today, and has represented mining companies on a variety of issues. Her practice also focuses on the U.S. Foreign Corrupt Practices Act and on other anti-corruption laws around the world. She appears before the SEC, the Department of Justice, and other enforcement agencies on behalf of her clients. Veronica Kohler, to my immediate left, is the Director of International Policy at the National Mining Association, where she leads the association's engagement on international issues that affect the members' operations, whether domestic or foreign. She comes to us with a very unique set of experiences in the mining sector, and I think a unique perspective on the impact that these rules or that mining has on development. She joined the National Mining Association in 2010 after having spent 5 years at the World Bank in the Sustainable Energy, Gas, Oil, and Mining Policy Division. While at the bank, she worked on mining projects, mostly in Africa, including in the DRC and in surrounding countries, but also in Central and South America and in Asia, and on overarching global issues impacting the mining sector and affected communities. Veronica also managed daily operations of the Communities and Artisanal and Small-Scale Mining Secretariat. So, assuming
that the rules specify. The rules define not de minimis to mean any payment that equals or exceeds $100,000 during the most recent fiscal year, and the types of payments that must be disclosed include taxes, royalties, fees, production entitlements, bonuses, dividends, and infrastructure improvements. The rules require a resource extraction issuers to provide information concerning the type and total amount of payments made for each project, the type and total amount of payments made to each government, the total amount of payments by category, the currency used, the financial period in which the payments were made, the business segment of the resource extraction issuer that made the payments, the government that received the payments and the country in which the government is located, and the project of the resource extraction issuer to which the payments relate. The rules leave the term project undefined. The rules also specify how this information is to be disclosed. They require the resource extraction issuer to file a new form called Form SD on EDGAR. And it also specifies when it must be disclosed, and the timetable is no later than 150 days after the end of the issuer's fiscal year.
Great, thank you, Rob. And I think Veronica was going to give us an overview of the conflict minerals requirements.
Sure. Let me just mention I've been battling losing my voice the past couple of days, so please let me know if you do not hear me, and I will try to step it up for this hour and then not have the voice for the rest of the week. I wanted to start out with saying NMA, the National Mining Association, has not joined any of the two lawsuits that we will be discussing.
I just want to give a very brief introduction here to our panelists and then turn it over to them. But on behalf of the D.C. region of the ABA's White Collar Crime Committee that Alex Walsh and I co-chair, we're delighted to have this great panel today. Thank you so much for taking your time out to give us this presentation, and thank you for those of you who came here in person and on the phone. Without further ado, I'll turn it over to my partner, Brittany Preliger.
Thanks, Brian. Thanks to the D.C. region of the D.C. Bar White Collar Committee for having us. Thanks to all of you for coming, and for those on the phone for listening in. And thanks as well to Arnold & Porter for hosting us this afternoon and for the delicious lunch. We should note at the outset that this session is being recorded, which means that nothing that's said here is off the record. We're here to discuss a new set of disclosure requirements that are imposed as part of the Dodd-Frank Act of 2010, Sections 1502 and 1504, and the related SEC rulemaking under these provisions, which were issued in August of this year. Both provisions aim to deliver social benefits that seem to most, I think, outside the SEC's normal investor protection remit. Section 1504 aims to increase transparency in resource-rich countries by requiring extractive issuers to disclose payments that they make to governments in those countries for the commercial development of oil, natural gas, and minerals. Section 1502 was a bit of an 11th hour addition to the Dodd-Frank Act. It aims to choke off the trade in conflict minerals, meaning tin, tungsten, tantalum, and gold, known as 3T. That there would be varying degrees of familiarity with the rules that we're talking about today. I've asked our panelists to start by just giving a brief overview of what they require, and we'll start with Rob, who is going to give us an overview of the extractive issuer disclosure requirements.
Right. Thank you very much, Brady. And I apologize for feeding you that run-on sentence in the middle of my bio there. I wasn't sure if you were going to make it to the end on one forever, but you did well. Thank you. As you might gather from my bio, my expertise is more in administrative law than it is specifically in mineral and mining regulations that, whether the CFTCs or otherwise. So I'm going to cheat off of a fact sheet that the SEC has published explaining what the resource extraction regulations require. You typically would want to go directly to the regulation or the statute, but this one appears to be pretty accurate, so that's what I'm going to use to cheat off of. So obviously the regulations require disclosure of certain payments made to foreign governments or the federal government by resource extraction issuers. So the rules have several features. They start off by explaining who is covered. They require a resource extraction issuer to disclose payments made to governments if the issuer is required to file an annual report with the SEC and the issuer engages in commercial development of oil, natural gas, or minerals. The regulations then go on to explain what must be disclosed. These issuers need to disclose payments that are first made to further the commercial development of oil, natural gas, or minerals, that are not de minimis, and that are within the types of payments